All right, again, welcome to this webinar on requirements for voluntary placement agreements for treatment. My name is Liz Bosnick. I am going to be one of the presenters today. I work at the Department of Children, Youth, and Families in our child foster care area. I sort of have two roles. I work on our QRTP team, and then also more specifically with foster care policy related to children and youth with complex needs. And I'm going to pass it to my co-presenter, Ashley, for her to introduce herself. And then we'll also introduce some of our other DCYF colleagues who are assisting us with this webinar.
Hey everyone, my name is Ashley Solzard Beckman and I am Child Foster Care Wellbeing Program Representative, work with Liz in our Child Foster Care Policy area. And for the last several years, as Liz mentioned, I've been doing a lot of work with partners in Department of Human Services and other areas to help counties and tribes manage things related to children with complex needs.
Thanks, Ashley. Alicia, I'll have you go next. Introduce yourself.
Hi, everyone. I'm Alicia Wolfman. I am a Permanency Quality Assurance team member in Child Safety and Permanency, and I will be assisting Ashley and Liz with the Q&A. I'll pass it to Abby.
Hi, everybody. My name is Abby Meyer, and I'm a child safety consultant here at DCYF with the Child Safety and Preservation Unit, and I will also be assisting with the Q&A.
Thanks, all. All right, here is the agenda for our webinar today. We are going to do an overview of child welfare and talk about some of the child foster care definitions and types of placement authority, which is a child welfare requirement. And then we will examine voluntary placement agreements. This webinar is going to specifically focus on voluntary placement agreements under Minnesota Chapter 260D, but we will talk about voluntary placement agreements under Chapter 260C, as well as just the voluntary placement agreement requirements in general. So before we discuss voluntary placement agreements, we're going to level set and discuss Minnesota's child welfare program and the child welfare requirements. Minnesota's public child welfare program is outlined in Minnesota Statute Section 393.07. And at a high level, Minnesota's child welfare program is administered locally by county and tribal agencies and supervised by DCYF along with partners at DHS. The purpose of the child welfare program is to assure protection for financial assistance to children who have social, physical, or emotional challenges and require protection or assistance for those challenges. This slide outlines some of those challenges, but to note, the challenges are not limited to those that you see on the screen. So foster care will be part of the focus of this webinar because voluntary placement agreements for treatment mean a child is in foster care. So foster care is a temporary court-monitored service provided by states to promote the safety, permanency, and well-being of children and youth. These next couple of slides are the specific foster care definition per statute. So foster care is defined as 24-hour substitute care for a child for whom a responsible social services agency, so a county or a tribe, has placement and care responsibility, and the child is placed away from their parent or guardian in foster family homes, foster homes of relatives, group homes, emergency shelters, residential facilities, and just childcare institutions in general, or pre-adoptive homes. But of note, a child is in foster care regardless of whether the facility is licensed and payments are made for the cost of care. And then lastly, foster care is intended to provide for a child's safety to access treatment. It cannot be used as a punishment or consequence for a child's behavior. And that is specifically outlined again in statute. So a core component of foster care is placement authority, which gives the agency, the lead agency, legal responsibility for the care and control of the child while the child is in foster care. And we have listed the statutes where the legal authority to place children is defined. So placement authority consists of a court order or a voluntary placement agreement, which must use a commissioner-approved form. So placement authority requires that the social services agency provide reasonable or active efforts to finalize the permanency plan for the child, adhere to ICWA, which stands for the Indian Child Welfare Act, and MIFPA, which stands for the Minnesota Indian Family Preservation Act, both of which are protections for Native American children and families. Placement authority also requires the agency to engage with the parent and the child to develop a child's case plan, and that the agency conduct required and that court reviews are conducted and permanency proceedings are held. Here are the types of placement authority. The terms and conditions of the placement authority vary depending on the type. As you can see, there are two types of voluntary placement, one under chapter Minnesota Statute 260C and the other under 260D. And again, for this webinar, we are going to be focusing on 260D, so the voluntary placement for treatment. However, we are going to review some of the high-level details about these types of placement authorities and also the child welfare requirements. And so in addition to the voluntary placement under 260C and 260D, there's also a voluntary placement of an Indian child. And then the last type of placement authority is a court order or CHIPS, which stands for a child in need of protection or services. All right, now we're going to dive into each of those placement authority types a little bit. So foster care under a CHIPS petition, which again stands for a child in need of protection or services, is not voluntary. And a CHIPS petition is filed by a social services agency or really anyone for that matter can file a CHIPS petition when it is believed that a child is in need of protection or services. With a CHIPS petition, the court makes individual findings that custody of the child by the parent or guardian would be contrary to the welfare of the child, and that foster care is in the best interest of the child. Voluntary foster care under 260C is the next placement authority that we're going to touch on. So this is a temporary agreement between the agency and the parent that states that the child's safety, health, and best interest require the child to be in foster care. Voluntary foster care under 260C requires the use of a specific form and parental notice, each that are dependent on whether the child is American Indian or non-American Indian. And on this slide, you can see those specific forms and notices. With this webinar, all of the links that are in blue and underlined will be clickable so that when you all get access to the slide deck, you will be able to use these for resources or for more information. And then for voluntary foster care under 260C, there are 90-day and 100-day required court reviews, as well as specific actions that the agency and court must take after the child has been in voluntary foster care for 180 days. And we will go more into court oversight and those requirements later on in this webinar. And those will be specific to 260D. But we did just want to highlight some of this information because it just underscores that there are different requirements when a VPA is completed under 260C. And again, you will see that later on as we talk more about those court oversights and requirements for 260D. And then lastly, voluntary foster care for treatment under 260D. This will be one of the focuses of this webinar. So 260D, voluntary foster care, builds on the idea of voluntary foster care under 260C. So there's also an agreement between parents and the agency. However, unlike 260C, 260D voluntary placement is specifically to provide necessary treatment that cannot be obtained unless the child is in foster care. It requires that the agency's juvenile treatment screening team determine that it is medically necessary. So typically when the agency screening team makes that decision, it's based on either the diagnostic and functional assessment under the Children's Mental Health Act or assessments under Services for Persons with Disabilities. And so then the screening team uses those assessments to determine the child's need for treatment due to an emotional disturbance, a developmental disability, or related condition, and that it requires the child to be in foster care and be in placement in order to get the necessary treatment. And so the agency would enter into that voluntary foster care agreement between the child's parent and the agency. And then the agency has that legal authority then to place the child in foster care and seek the treatment that the child needs. As with 260C, 260D requires the use of specific voluntary placement agreement forms and notices to parents, again, that are dependent on whether the child is American Indian or non-American Indian. So this slide, again, just gives those placement agreements and the notices to parents. And we are going to talk a lot more about ICWA and MIFBA and just how that plays into the child welfare requirements and then the 260D voluntary placement agreement for treatment. So when an American Indian child is voluntarily placed out of the care of their parent or custodian, notice has to be given within 7 days to the American Indian child's parent, custodian, and tribe. And then when a parent or custodian voluntarily consents to an American Indian child's placement, the consent must be executed in writing, recorded before a judge, and accompanied by the judge's findings in order for that voluntary consent to be valid. And so again, this applies to American Indian children and families and is specific to ICWA and MIFBA, which again, we are going to start covering here in a couple of slides. So there are statute outlines when 260D, voluntary placement agreement for treatment, does not apply. Those two scenarios are one, when a child maltreatment determination requires child protection services, or excuse me, child protective services, and also when a child is in foster care for any other reason than treatment. Here are some best practices for determining when to use 260C versus 260D for voluntary placements. Ashley and I have provided a lot of consultations with county agencies, and this comes up a lot, so it's why we wanted to share some of this information. So the first step would be to consult with your county attorney, and it would be looking at the 260C and 260D statutes and applying that to the case to determine which voluntary placement agreement would be appropriate. Also, cross-administration consultation with all the case management teams serving the child. So if the child has a waiver case manager and a children's mental health case manager and a child welfare case manager, it's important for all of those case managers to have collaboration to talk about the case as well as what that voluntary placement agreement is going to be. Also asking if foster care is medically necessary. As you recall from the previous slides, 260D requires that it be medically necessary. And so asking that question also will really help determine what would be the best voluntary placement agreement to move forward with. And then, as stated previously, following the recommendations of the juvenile treatment screening team. All right, now we are going to talk about the child welfare requirements. So the child welfare requirements apply to all children in foster care because they are federal protections. The child welfare requirements are outlined in chapter Minnesota Statute 260C. However, 260D notes that the child welfare requirements apply. So in general, the child welfare requirements ensure placement prevention, family reunification, and active and reasonable efforts. This next slide outlines at a high level the child welfare requirements that agencies must adhere to, follow, and complete. So again, foster care is temporary and it focuses on reunification and permanency planning for the child from day one. In the next few slides, we will go into depth regarding each of these boxes, but I'm just going to highlight some of the acronyms on this page. So as I've mentioned before, ICWA stands for the Federal Indian Child Welfare Act, and MIFPA is the Minnesota Indian Family Preservation Act. Then the next box, you will see the long acronym known as MAFPA CWTA, which stands for the Minnesota African American Family Preservation and Child Welfare Disproportionalities Act. This act is currently being phased in at the agency level following recent legislation. And so this slide gives a link to the implementation site for MAFPA CWDA. So if that would be something that you would want to review following this webinar, you have access to do that. All right. I promised that we would talk about ICWA and MIFPA, so here we go. So ICWA and MIFPA are foundations of the foster care requirements. They are very complex, so we are only going to touch on a couple of high-level points and some of the most critical first steps in a child's case. So what is ICWA and MIFPA? And as I've mentioned before, ICWA is the federal law that was created to protect and preserve Native American families, and it stands for the Indian Child Welfare Act. And it required social services agencies to partner with tribes as children access social services. Then MIFPA is Minnesota state statute that further strengthens ICWA protections for Native American children and families. And MIFPA again stands for the Minnesota Indian Family Preservation Act. The first most critical component of ICWA and MIFPA, and the one that often gets missed with a child's case, is inquiry. An inquiry is asking a parent, custodian, the child when appropriate, immediate and extended family, as well as other persons such as child's teachers or service providers, reporters of child maltreatment, about a child's tribal affiliation and or heritage. The purpose of inquiry is that it lays the groundwork for compliance with both MIFPA and ICWA, and it is required to determine whether someone is American Indian or has American Indian heritage. The results of inquiry are also important because they determine specific court oversight requirements and the type of voluntary placement agreement, as well as the notices, which we covered in the previous slides. And then the second most critical component happens once a child's tribal affiliation or heritage is determined. And that is the county agency is required to partner with the tribe during every step of case planning, every single step. Tribes are privy to every piece of information that counties are, and tribes are equal to what counties have access to. So there's no need for releases of information, and counties are required to share everything, such as case history, assessments, out-of-home placement plans, or any other service plans that are developed. As mentioned, the ICWA-MIFPA requirements can be complex. So here are some ICWA-MIFPA resources as well as some past trainings. And then we've also included contact information for the ICWA-MIFPA team at DCYF, which is the first bullet on this slide. And so we would really encourage folks who have questions or ideas or would like to consult on specific cases to reach out to our DCYF American Indian Wellbeing Unit. Also just wanted to mention that ICWA was codified into MIFPA in 2023. I realized that that got left off of one of the previous slides, so wanted to mention that important piece as well. All right, so moving along with the child welfare requirements, next we're going to discuss reasonable and active efforts. And reasonable and active efforts is really a reflection of a case manager's work prior to placement being determined to be necessary. Reasonable and active efforts are to prevent placement, reunify and finalize the child's permanency plan, and agencies are required to detail their reasonable and active efforts. We encourage those county staff who are attending today, if you're not in your child welfare area or team or department, to collaborate with your child welfare area because there are typically your child welfare area has access to tools and resources for these efforts. And then also, active efforts is required when ICWA and MIFPA applies, and also MAFPA CWDA. And so there's a requirement to use culturally appropriate and available services to prevent placement and eliminate the need for removal. Next, we're going to talk about the Foster Care Sibling Bill of Rights, which is outlined in Minnesota statute, section 260C.008. So a child placed in foster care who has siblings has the right to, and I'm going to read the slide because this is so important. So a child placed in foster care has the right to be actively involved in and have frequent contact with their siblings. They have the right to participate in face-to-face visits with siblings, and these visits cannot be withheld or restricted as consequences. They have the right to be included in permanency planning decisions for siblings when appropriate. They have the right to be placed in foster care homes with siblings or in close geographical distance. And when that's not possible, frequent and meaningful contact is facilitated. And then lastly, they have the right to be promptly informed about changes to siblings' placements or circumstances, including how to have continued contact after adoption or transfer of permanent physical and legal custody to a relative. And be actively involved in and have frequent contact with siblings includes things such as phone and video calls, social media, email, regular mail, texts, photos, and celebrations such as birthdays, holidays, graduations, school and extracurricular activities, cultural customs, and other milestones. And then lastly, adult siblings have the right to be considered as foster care providers, adoptive parents, and relative custodians for a child in foster care. So the Sibling Bill of Rights must be explained to and given to a child in foster care. using a commissioner-approved form, one that you see on the screen. The Sibling Bill of Rights has been translated into several different languages, as you can see on this slide. And these forms are available in the DHS document library, also known as eDocs. But again, these are direct links to these forms as well. So when you all get a copy of this PowerPoint, you will have that at your fingertips. All right, moving right along here. So now we're going to talk about relative and kinship searches. So again, relative and kinship searches are required regardless of the placement authority type. And the purpose of these searches is to give notice to relatives and kin about a child in foster care, for the relatives and kin to be considered as placement options for the child, and or to be involved in case planning for the child, as well as to assess a non-custodial parent's abilities and provide any necessary services. Courts cannot waive the relative and kin search process. The definition for relatives is outlined in 260C, both for American Indian children and non-American Indian children. And then the last box on the screen is a link to a best practice guide for relative search, notice, and engagement and placement considerations for children in foster care. All right, the out-of-home placement plan, another child welfare requirement. So this out-of-home placement plan documents how the agency and the parent are planning for the child's safety, permanency, and well-being. The out-of-home placement plan is prepared and signed jointly by the child's parent and or guardian, the case manager, and tribe within 30 days of the child being placed in an out-of-home placement. The out-of-home placement plan is also submitted to the courts, and it must be reviewed and updated at minimum every 6 months and anytime there's a placement change. A summary of the out-of-home placement plan is provided to the parent and or guardian. And again, it documents the reasonable and active efforts by the agency and the parent to support reunification. I want to just highlight a couple of important things regarding preparation for the out-of-home placement plan, as Ashley and I and our team have found that there are some misconceptions here. So preparation of the out-of-home placement plan must include the foster parent, relative or non-relatives, and or the residential provider. And that's because the out-of-home placement plan outlines the services the child is receiving from the foster parent or provider. And then the foster parent or provider also receive a copy of the out-of-home placement plan. And then lastly, the out-of-home placement plan is not the same as the community support plan or the coordinated services and support plan. I'm going to just say that one more time because it's so important, and we see this a big misconception here. The out-of-home placement plan is not the same as the CSP or the CSSP. This next slide is just some resources for the out-of-home placement plan. So again, once you, excuse me, get a copy of this slide deck, you'll be able to click on these links for additional resources. All right, permanency planning is the next child welfare requirement that we will discuss. So the permanency plan is the established goal in the out-of-home placement plan that will achieve a safe and permanent home for the child. We will discuss more about permanency planning requirements for voluntary placement agreements under 260D later on in this webinar. Monthly caseworker visits, also another child welfare requirement. These caseworker visits are vital because they are federal requirements and they're linked to federal funding. So part of Oh, and excuse me, and it's also part of a case manager's assessment and case planning work. And the percentage of caseworker visits affects Minnesota's receipt of Title 4B funding. So the purpose of the monthly caseworker visits is to assess safety, permanency, and well-being to promote achievement of the child's case goals. The majority of the caseworker visits must occur in the child's placement setting outside the presence of others. So, for example, outside the presence of parents or foster parents or facility or residential provider staff. The visits must at minimum occur monthly, but they can be more frequent based on a variety of things such as safety concerns, needs of the child or caregiver, any presenting issues, or level of risk. And then documentation of the caseworker visits is required in SSIS. And that last bullet on the slide, again, is a clickable link for a best practice guide related to these visits. All right. This is the last slide in our child welfare requirements section, and then we will be jumping into specifically 260D, which I know you all are eagerly waiting for since that is the focus of this webinar. So lastly, and to sort of wrap this up, all of the child welfare requirements that we've talked about, they must be documented in SSIS because that is Minnesota's data recording system for federal reporting requirements. So everything from the placement authority type is documented in SSIS to the out-of-home placement plan to the ICWA and MIFPA pieces that we've talked about to those caseworker visits. All right, I'm going to be passing this off to Ashley now. I did just want to mention again for folks that maybe have joined late, we are recording this webinar. And so following this webinar, the recording, a copy of the slide deck will be available. And then we will also be compiling questions into an FAQ document that we will also publish. If you have questions throughout this webinar, please use the Q&A function. And then at the end of this webinar, we will have some time to answer some of the questions that have been asked. All right, and I will pass it off to Ashley.
Liz, and thank you everyone for submitting your questions, and we will get to some of them when we are finished with our presentation. So now we're going to dive into some of the specific requirements that are under Minnesota Statute Chapter 260D, also known as voluntary foster care for treatment. Next slide, please. So the intention of Chapter 260D is to provide the means for the agency to and the parent to allow a child with a developmental disability or mental illness the ability to access treatment that the child would not be able to access if they were not in foster care. And foster care in 260D, just like any other foster care, is meant to be temporary. So whether foster care is voluntary or involuntary, it's still always meant to be temporary. And so when we are looking at a child going into foster care for treatment, there's a phrase in hospital discharge planning that you plan your discharge starting from the admit. And that's what we would be expecting as part of the active efforts of reunification and placement prevention to be planning for that child to return home right at the beginning. So some of the intentions that are outlined in Chapter 260D is to preserve and strengthen a child's family ties, and that placement for the child away from the parents is only done when required to access treatment that cannot be accessed if not in foster care, and the child cannot be maintained safely in the home. Lastly, the intention in Chapter 260D is for to really highlight that parents retain legal custody and decision-making authority for the child. Next slide, please. So again, the primary focus for voluntary foster care for treatment is to support the legal parent-child relationship by maintaining the parent's legal authority and responsibility for ongoing planning for the child, and to support their ongoing right and obligations to have visitation and reasonable contact with the child. So we're going to talk a little bit more now about what ongoing planning means. And because statute identifies what does ongoing planning mean for the parent. So that is active participation in planning and provision of educational services, medical and dental care for the child. So for example, if a child has an IEP, this would mean that the parent would have the right and obligation to participate in IEP meetings and to help with that planning. It would mean working with the agency and the school district to advocate for appropriate educational services or appropriate educational settings. Some examples of medical needs would be psychotropic medication oversight, making sure that the child is not over medicated, understanding the side effects of the medication on the child, working with the agency, with the residential provider, with the healthcare prescriber to understand if the medications are working for the child and what effect they're having. Active planning and participation with the agency and the residential provider for the child's treatment needs. So whether a residential provider is a mental health-based provider, such as a residential treatment program or a waiver services provider, there are regular service planning meetings that the provider sets up in order to evaluate goals and objectives that the child is working on while in their care. So this active planning and participation would include attending those meetings and participating in reviewing this goals and objectives. Goals and objectives might include group or individual therapy, skills work, behavior management plan, independent living tasks. The parent has a right and responsibility to be involved in these meetings. And again, it's really important for the parent to be involved in these planning meetings to understand how the child is progressing on treatment for the reason that they're in foster care for treatment, and to learn what interventions are working so the parent can work with the agency to identify methods that they can use when the child comes back home, natural supports that they might be able to access to help them, support them when the child comes home, and maybe even start thinking about external services that can come into the parent's home and assist the parent and the child upon reunification. As a reminder, a child in voluntary foster care placement for treatment under 260D, when they are in that, relative search and engagement is still a requirement. Typically, agencies have a specific team that completes these tasks, and that team often has specialized training and access to special research tools to assist in the process. When a child is placed in a QRTP, the parent does provide input about who may be included in the relative search. But yes, a relative search is still required under 260D. Next slide, please. So when a child is in voluntary foster care for treatment, they have rights as well, and those are identified in statute. They have the right, and they must be informed of those rights as well when they're ages 12 and older. They have a right to be consulted in the preparation of their out-of-home placement plan and in the administrative review, which we're going to talk about in a minute. the right to visitation with their parent and their siblings. They have the ability to request a court hearing. So some of the reviews, like the judicial review that we're going to talk about in a little bit, doesn't necessarily have to be done in court, but a child can request that they have an in-court hearing. They also have rights established under Minnesota Rules 2960.005, and that's for facilities that are licensed under those rules. Next slide, please. Thank you. Okay, so because voluntary placement is still foster care, if you remember back when Liz gave us the very first slide about what is foster care is overseen by the court. So regardless of if it's voluntary or an involuntary, the court still has oversight of out-of-home placements for children. The requirements of the oversight outlined in Chapter 260D are not the same as the requirements in Chapter 260C, so that is why we are going to be talking about those now. First, as a reminder, with ICWA and MIFPA, like Liz said earlier about the importance of inquiry, any child that is going into an out-of-home placement, regardless of if the child is presumed to be Native American, inquiry must be done. And one of the reasons why that is so important when we're talking about voluntary placement is that that voluntary placement agreement needs to be signed in front of a judge in order for it to be valid when ICWA and MIFPA apply. So that is just once again demonstrating why it is so important to do inquiry right at the very beginning of a child's interaction with you and when you are considering with a parent on if the child needs out-of-home placement for treatment. Next slide, please. So we're kind of going in like chronological order here. So ICWA MIFPA inquiry first. If the child is going into an out-of-home placement under voluntary placement agreement, they get it signed in front of a judge. Now, if you are placing the child into a qualified residential treatment program, the next step would be a 60-day court review and approval. So within 60 days of the child's placement in a QRTP, you need to get court review and approval. Then there are ongoing court reviews, which we're going to talk about a little bit more. And at each of those court reviews and administrative hearings, you would be needing to submit all of the information that's required under 260C.712. And we also have a template for you to use for QRTP placements for court reporting. Next slide, please. Next would be the administrative review. What is an administrative review? First of all, we can see that once again, the requirements in 260D are pointing back to 260C. So we're building upon 260C requirements for child welfare in 260D. An administrative review is conducted by the responsible social services agency, so the county or the tribe, using a panel with at least one person who is not responsible for case management or service delivery for the child or the parents. It's open to participation by the parent, the child, and the tribe. And this needs to occur before the court report submission required for the 165 days judicial review. Now that's kind of a mouthful and that's a little bit challenging to understand about these timelines. In chronological order, this would be occurring after the QRTP 60-day court review and before the judicial review. So this is an internal review by the agency, conducted by the agency to review the out-of-home placement. After the first review, an administrative review occurs every 6 months afterwards. Next slide, please. So the administrative review includes assessing the appropriateness of the services provided to the child, updating the out-of-home placement plan and the independent living plan if the child is 14 years and older, and then assessing compliance with the out-of-home placement plan and progress towards the goals in the independent living plan. So when we're talking about assessing appropriateness of services for the child, you're looking at the extent to which the services that are being provided, what their progress is to alleviate the cause of placements. How are the services helping the child achieve the treatment goals that have been set in order to get them to come back home? So for example, if the child is in a waiver supported out-of-home placement, we would be looking at the services that would be provided under the waiver. Or how are they assisting the child? What progress is being made on the child's goals? And how are these services supporting both the child and the parent in getting the child to be able to come home? And always we are looking at the projected date, again, when the child will be returning home. So once again, discharge planning starts on the day of admission. We are always looking at how are we going to get that child back home and achieve permanency. Next slide, please. Next, the judicial review. The judicial review process is initiated by submitting a court report, including the voluntary placement agreement addendum, to the court, and the judicial review is completed within 165 days of placements. There are court report templates and a court report voluntary placement agreement addendum template, as well as the QRTP addendum template that are available for you to be using when you are submitting these court reports. Once the court has received the reports, then they make a determination within 10 days. Next slide, please. Just like with the administrative review, the judicial review requires you to notify the child's parent, tribe, foster parent, residential provider about the court report and the review and their right to submit information. You need to tell them what date you're going to need it in order to submit it to the court timely, and also about their right to request that in-person or in-court hearing with the judge. If it is requested by one of those folks, if it's requested by the child or the parent or the foster parent or residential provider, then there is an in-court hearing. Next slide, please. So this is some of the information that is in the court report. As I mentioned before, we have court report templates, and some of this information is included in those templates. And then there's also information for voluntary placements under 260D that you would be submitting as an attachment or as an addendum. And we'll go over that in just a moment. So if the parent, the child, the tribe, or the residential provider wants to submit any other information for the court to consider, then they would be providing that so that you could submit that as part of the report. That's part of that notification that we talked about earlier. Next slide, please. Here is some of the other information that would be submitted to the court. So a copy of the out-of-home placement plan. If the child is 14 years or older, you would also have that independent living plan. Statute identifies that when a child is placed due to a mental illness, you would also be submitting an individual treatment plan or what they call the standard written plan. When a child is placed due to a developmental disability or related condition, that would be the individual service plan, program plan, waiver care plan, or standard written plan. So for most waiver case managers, that would be the community support plan or the coordinated services and support plan. When the child is placed in a QRTP, you're also submitting that other information that is identified in 260C.712. And Liz and the rest of our QRTP team will be providing a webinar next month that will be going over some specific QRTP requirements in more detail. Next slide, please. So after the judicial review, if the child does continue to be in placement, then for 13 months from the date of the voluntary placement, or has been in placement for 15 of the last 22 months, then the agency has certain actions that they need to be taking. So either the voluntary placement agreement is terminated and the child returns home, or if the agency determines there are compelling reasons to continue the VPA, then they need to seek a judicial determination to approve that determination, or they need to file for a termination of parental rights. So if an agency is looking to continue the voluntary placement, if the parent and the agency feels that that's appropriate, statute says they need to determine compelling reasons. So what are compelling reasons? Let's look at that next. Compelling reasons has a definition in statute. We have a definition in 260D, which once again immediately points to 260C. It has the same meaning as in 260C.007, subdivision 8. And then it further expands on it by saying an agency may determine when there is a voluntary placement for treatment and there are no grounds, may determine compelling reasons that they should continue the voluntary placement for treatment, and there are no grounds to terminate parental rights because either, or not either, sorry, these are all and statements. Placement is required to access treatment, and the individual treatment needs cannot be met in the child's home or community-based care, and the parent continues responsibilities for planning with the agency for the child's needs, and the parent maintains appropriate contact with the child. So that phrase about the parent continues responsibilities for planning with the agency for the child's needs, that is very reminiscent of the language that we saw back talking about the parent's ongoing responsibilities for planning and planning for the active participation in planning in the child's care. So those would be the things that the agency would be looking at when they are determining compelling reasons. Next slide, please. If the agency does determine that compelling reasons exist, then they would submit a petition for permanency review hearing regarding a child in voluntary foster care for treatment. This particular petition is drafted or approved by a county attorney under oath, submitted to court, and then a permanency hearing date is set. So this is a really good reminder on how important it is when you are working on or considering a voluntary placement agreement for treatment, that you work with your county attorney, because ultimately, if the child remains in voluntary placement for treatment, they are going to continue to be involved with all of these court processes. So at that permanency hearing, the court makes one of two determinations. Either they approve it or they deny it. And if it is denied by the court, then the child must be returned home, or the agency needs to file a petition, a different petition under 260C.141. Or if the voluntary placement agreement, the judge makes the determination that it can continue, then this continues to be, the VPA continues to be under court jurisdiction. And an annual review hearing must occur then every 12 months. And I have one other thing to say on this, but my notes are too long. Oh, no, that's all I wanted to say on that. We're going to talk about the annual review hearing next. Thanks. So the annual review hearing, again, this occurs every 12 months while the child is in foster care, and the court gives notice to the parent and the child ages 12 or older, and the parent, foster parents or residential service provider to review the requirements. And the court determines if the agency has made reasonable efforts to finalize the permanency plan for the child. So reasonable efforts, what does that mean? Reasonable efforts means that the agency is continuing to ensure that the voluntary foster care is the most appropriate legal arrangement for the child's health, safety, and best interests. So these sorts of things would be determined, through that administrative hearing or administrative review every 6 months. The agency is continuing to assess whether this is the most appropriate situation for the child. Reasonable efforts also includes engaging and supporting the parent in continued involvement in planning and decision-making needs for the child, strengthening the child's ties to the parent, relatives, and community, and then making sure that the out-of-home placement plan is updated and being implemented by the agency, by the residential service provider, by the parents. Now, just to also put in here, even though I had said previously it's under court jurisdiction and then we have this annual review hearing every 12 months, if at any point the parent or the agency or the tribe wants to end the voluntary placement agreement, that is still possible without going to court. And we are going to talk about that next. Termination of a 260D voluntary placement agreement. So if ICWA applies upon demand by the parent or Indian custodian, the child must be returned to them as soon as possible and no later than 24 hours after receipt of the demand that the child be returned. If ICWA does not apply, then the agency, the parent just notifies the agency in writing to end the agreement, and the child is returned within no earlier than 72 hours and no later than 30 days. And then finally, the process for the agency to terminate a 260D voluntary placement agreement would be to provide written notice to the parent, including information about the parent's right to a fair hearing and how to appeal decisions. If the agency is the one that is ending the voluntary placement agreement, then they are required to work with the parent to do the parent and the residential provider to do transition planning for the child to return to the parent's care. Okay, I think that is it. So I am going to stop recording, and then we are going to answer questions. And once again, if you're watching this later on, all of the questions are going to be compiled into an FAQ that will be posted on our website with a recording of this webinar and the slide deck.
Actually, I'm just going to jump in here with a couple of things real quick. So some folks who have posted some questions in the Q&A have gotten a response asking that they send the question either to like our foster care email or something along those lines. And that's because the question likely needs some more individualized connection with the person asking the question. Sometimes the answer is based on the individual case. And then didn't mention before, but the webinar recording, the slides, and that FAQ document that we will be compiling based on all the questions that we receive. Once those are published, they're going to be on the same website that you registered for this training. DCYF is giving a series of webinars. They started in June and they will go through October. And so as those webinars are completed, then the webinar recordings and slide decks and things are posted in that same spot so you can see what's happened and what's upcoming.